Hello everyone, welcome back to our channel Legal Nexus. In today's video, we are going to discuss a very important concept under the Indian Contract Act, bailment. Bailment is a common part of our daily life, whether we realize it or not. Whenever we hand over goods to someone else for specific purpose like leaving clothes at the dry clean or giving vehicle for valet parking, a contract of bailment comes into play. In this session, we will understand that bailment means the essential features, the rights and duties of both the bailer and bailee, along with some practical examples and case laws. Bailment, Section 148 to 171 of the Indian Contract Act 1872 contain the provision relating to contract of bailment. The term bailment originated from a French word bailler, which means to deliver. The delivery of goods by one person to another for some specific purpose upon contract that these goods are to be returned when specific purpose is completed. That person delivering the goods is called as bailer, and the person to whom the goods are delivered is known as bailee. For example, A gives his auto to B, his neighbor, for 50 days. After that same time, he keeps one key with himself. During the period of 50 days, he used to the auto himself. Now, this will not be a case of bailment, as A keeping control over the property bailed. Essentials of bailment. The following are the essential ingredients of bailment. Delivery of possession. Delivery of goods should be upon a contract. Delivery of goods must be for a specific purpose, and return of goods. Delivery of possession. The first unique feature of bailment is that the bailer must transfer his possession of goods to the bailee. The goods should be put in the legal possession of the bailee. Mere custody of goods does not create the relationship of bailer and bailee. Section 149 explains how the delivery of goods is to be made to the bailee. The delivery of goods must be made by doing anything which has the effect of putting the goods in the possession of the intended bailee or of any person authorized to hold them on his behalf. Delivery of goods should be upon a contract. Bailment is based on a contract between the bailer and bailee. When a person's goods go into the possession of another without any contract, there is no bailment. However, a finder of lost goods of another is considered to be a bailee. Even though there is no real contract, the contract may be expressed or implied. Delivery of goods must be for a specific purpose. Section 148 provides the delivery of goods from bailer to bailee must be for some purpose. If goods are delivered by mistake to a person, there is really no bailment. However, by virtue of Section 72 of the Act, the person who received the good is under an obligation to return it. If there is any loss of the goods, the person to whom the goods were delivered by mistake will be liable for the loss. Return of goods. In a contract of bailment, goods must be delivered on condition that the goods should be returned to the bailer or disposed of according to his direction, either in their original or in an alternative form, when the purpose of bailment is over. In the case of Fasal versus Salman Rai, the defendant was holding the plaintiff mare under the execution of decree. The plaintiff satisfied the decree and the court ordered delivery of the mare to the plaintiff. The defendant refused to do so. The mare was stolen from his custody. The court held that after the delivery order, the relation of bailer and bailee was established by the virtue of explanation to Section 148 of the Act. Alston vs. Nichols. The coat of the plaintiff was taken away by an attendant while he entered a restaurant. The coat was hanged on a hook at the place chosen by the attendant in a suit claiming compensation for loss of the coat. It was held that the restaurant keeper was liable. The court held that the coat was delivered to the attendant who was accepted delivery for and behalf of the bailee. In a contract of bailment, there are primarily two parties involved, one the bailer and the other the bailee. Bailer. The bailer means the owner of the goods or property who transfer the possession of that good to another person but for a temporary duration. It means that in the contract of bailment, the ownership of goods or the property remains with the bailer, but its physical custody is transferred to the bailee for a particular period or till the accomplishment of a particular purpose. Bailee. The bailee is the person or entity to whom the goods or property are delivered by the bailer temporarily. The bailee holds the goods or the property for a certain period and it is responsible for its care for that period. Also, the bailee has to follow the direction, if any, issued by the bailer. On the basis of bailment, bailment can be classified into gratuitous bailment and non-gratuitous bailment. Gratuitous bailment means product without any charges or reward is gratuitous bailment. In this type, there is no requirement to pay any charges by the bailee for the bailment. Non-gratuitous bailment. Non-gratuitous bailment means the bailment for some reward or charges in non-gratuitous bailment. It is required to pay some charges to the bailer by the bailee. Duties of bailer. Disclose the facts. The bailer must disclose all the facts of the goods delivered by bailee. It was defined under section 150 of the Indian Contract Act 1872 to bear all the expenses. The bailer must pay the ordinary expenses to bailee. If there are any extra expenses, he is bound to pay the extraordinary expenses. To indemnify the bailee. The duty to indemnify the bailee refers to the responsibility of the bailer to compensate the bailee for any loss, damage, or liability incurred during the period of bailment. It is an essential aspect of a bailment relationship where the bailer entrusts their property to the bailee for a specific purpose, compensation for premature termination. It is the duty of the bailer to compensate the bailee if the bailer has terminated the bailment. In case of incurring any loss, then it is the duty of the bailer to compensate. To take back the goods. The bailer must take back the goods from the bailee when the specific purpose has been fulfilled. Duties of bailee. Duty to take care of goods. Bailee must take care of the goods until he returns the goods to the bailer. It means bailee has to take a responsible care of the bailed property. This means the bailee has to protect the bailed property from damages, theft, and any harm that may occur during the period of bailment. Duty to use the property for the agreed purpose. The bailee must use the bailed property only for its entrusted purpose without the consent of the bailer. If he deviates, it would lead to the liability of the bailee. Duty to not mix the property. The bailee is responsible for not mixing the bailer's goods with the other goods. If the goods are mixed, he will be held liable if the goods are unable to separate. If the goods can be separated, the bailee will bear the expenses to separate the mixed goods. Duty to return the property. If the purpose of the bailment is fulfilled upon the agreed period, the bailee must return the property to the bailer of the bailment. If fulfilled upon the agreed period, the bailee must return the property to the bailer. Duty to render accounts. When the bailior approaches the bailee for information regarding the status of the property bailed and the condition of the property, the bailee must provide accurate reports of all transactions connected to the bailment, and the bailee is required to maintain correct records. Like duties, the bailior and bailee has some rights also. Rights of bailee, right to possession. One of bailie's rights is to have possession of the goods that are subject to the matter of the bailment, but the right to possession is limited. The bailee has to use the goods only for a specific purpose, not for any other purpose, without the consent of the bailior. Right to lien, the bailee has the right to lien, which means the bailee can take back the possession of the goods bailed by the bailior until the charges are paid in respect of the goods. This right would be applicable when there is a legal contract between the parties, for example, a contract of bailment. Right to recover compensation if the bailior does not disclose any facts than any expenses incurred by the bailee has the right to compensate for the damages he incurred. Rights of the bailior. Right to terminate the contract. The bailior has the right to terminate the contract before the purpose of the bailment has been completed, but the bailior has to compensate the bailee for any loss incurred due to termination of bailment. Right to take the goods back. The bailior has the right to take back the goods after the purpose of the bailment has been completed in specific time if mentioned. Right to sue. The bailior has a right to sue the bailee in case of breach of contract. If the bailee fails to fulfill the contract terms, then the bailior can sue for breach of contract. So, that was all about bailment, a contract where goods are delivered for a specific purpose under an agreement and then returned once the purpose is completed. We learn its essential rights and duties of the bailior and bailee, and also saw how bailment apply in our day-to-day life. Understanding this concept is very useful because it is not only forms a key part of contract law but also connect directly with the practical situation we often face. If you found this video helpful, please don't forget to like, share and subscribe for more legal insights.